professor both in Buenos Aires and here in Girona. His current research lines are focused on philosophy of private law and particularly tort law. And on this field he has written several papers and a book which is called Fundamentos Económicos de la Responsabilidad Extracontractual, published in 2009. And he's currently actually preparing a second book on this field. Diego?
Thank you, Pablo. I have prepared a short version of my paper in order to read it. It will be much clearer, I think, than if I try to present it orally.
Did you take out all the mistakes?
All the mistakes.
But I'm afraid very, very short.
No, I think I added some others. The idea of the paper is to present three objections to the mixed conception of corrective justice, and then present my own account of tort law, which I think preserves the main tenets that are on the basis of corrective justice, of the mixed conception of corrective justice. Any theories familiarized with tort law will recognize that certain features are distinctive of the practice. First, tort law protects some kind of primary rights, whose violation triggers secondary obligations of repair. Second, these primary and secondary rights of the victims are correlative to primary and secondary duties of injured. For this reason, it is claimed that there is a normative connection between victims and injurers, which is very special. The victim has a right to recover from the injurer, and from no one else, the amount of the harm suffered, no more nor less, and the injuries owes the victim, and no one else, the same amount. Finally, the obligation to repair can be regulated by a full liability rule or by a strict liability rule. Sometimes we are liable for the losses we cause to others without fault on our side. This list does not intend to exhaust the relevant features of the practice. Nevertheless, I think it fits the standard description of its central aspects, and that any plausible theory should be able to account for them. Let's see how the misconception accommodates these elements. This conception of corrective justice interprets tort law in terms of two central concepts: wrongful losses and moral responsibility. Regarding wrongful losses, they result from the invasion of rights or a setback to legitimate interest by wrongful actions. Invasions of rights can be justified or not. This means that in order to consider that the loss is wrongful, it is irrelevant whether the conduct that creates is a wrong or not. In contrast, the setback to legitimate interest only concerns corrective justice when it is the consequences of a wrongful action. Thus, the absence of fault prevents the victim from getting compensation for the losses related to her legitimate interest, but it does not prevent her from recover when her rights have been violated. That is, the absence of fault does not always defeat liability. Things are different regarding agency defeating excuses. The absence of agency works as a general exclusion of liability, because without agency there cannot be wrongful losses, not responsibility. As to moral responsibility, Coleman does not offer a complete account of it. He appeals to this intuitive notion to explain that the duty to repair wrongful losses is not grounded on the fact that they are the consequence of a wrongful action, but on the connection the injury has with them. According to Coleman, by exercising their autonomous agency, individuals change the world. They make their mark on it. In a way, we come to understand individuals and ourselves through actions and the consequences they have on the world. The two elements of forensic justice are conceptually inseparable. The very definition of wrongful loss presupposes the intervention of human agency. Therefore, wrongful losses are impossible without a particular individual being responsible for them. The mixed conception articulates the values of human well-being and individual responsibility, establishing a particular way of addressing the problem of wrongful losses. The agent that the agent that is more responsible for them, for moral losses has the obligation to repair. For this reason, corrective justice, just as is defined by Coleman, explains the correlativity of the parties' rights and duties. The victim has a right to recover from the injurer because the loss that calls for redress belongs to the latter. In the same line of reasoning, the injurer ought to make good on the victim's loss because this is the only way he can get back the loss that belongs to him. In a nutshell, this is the normative core of the misconception. Let's see some possible objections to it. First of all, I want to argue that the misconception of corrective justice leaves tort law normatively unsupported. How could the mixed conception deprive the practice of a solid normative foundation? In order to other conceptions of corrective justice, like the one defended by Weinberg, for example, corrective justice is a principle that honors the equality of individuals as self-determined moral agents. For liberalism, self-determining agency seems to be the kind of value that can justify tort law. Likewise, in the case of the Nunen thesis, the morality of eliminating wrongful losses is rather obvious. After all, what else are we supposed to do with unjust losses but to eliminate them? In contrast, within the framework of the misconception, the moral value of imposing the obligation to repair wrongful losses on those who are morally responsible for them is not easy to grasp. One might think that it is quite annoying to ask about the moral value of imposing the duty to repair on the person who is morally responsible for the loss. The answer seems so obvious that the question does not deserve to be asked. However, I think it's not obvious at all. Coleman's accounts of moral responsibility is not much more than mere authorship, understood in terms of what we cause in the world. Therefore, the question can be reformulated in a way that results interesting again. Why morality or justice requires that losses are repaired by those who cause them, and not by other person or the state. Even from a conceptual point of view, one might have reasons not to rely on the explanatory power of the mixed conception. Once wrongful losses are defined as resulting from fault or the invasion of rights and responsibilities reduced to causation, no one will deny that tort law imposes, and I'm quoting Jules, imposes a duty to repair wrongful losses on those agents responsible for them. Basically, this is what tort law does, at least in its remedial aspect. Ultimately, it seems the mixed conception itself is in need of an explanation. Coleman can escape this problem by finding a moral ground for this conception of corrective justice. To that effect, he can appeal to the values underlying the mixed conception. As we saw, corrective justice reflects liberal values of equality, respect for persons and their well-being, as well as responsibility for the consequences of one's actions. Tort law imposes on injurers the obligation to repair the wrongful loss they cause in order to make them responsible for their actions and to protect human well-being at the same time. Unfortunately, this is not enough because the following question immediately comes to our minds. Could these two ideals not be honored by mechanisms other than corrective justice, among other possibilities, with compensatory funds for victims and sanctions for injurers? These two values can always be satisfied by the state implementing institutions under tort law, but then one explains tort law. Here the idea is to apply the same criticism Jules directed against the law and economics, the bilaterality criticism, saying that if what justifies corrective justice or misconception is responsibility and well-being, you could make people responsible by one set of institutions like criminal law, and you could protect people's well-being by another institution like a compensatory fund, general fund for victims. Another question I would like to raise is whether the mixed conception of corrective justice can account for all strict liability cases that emerge in contemporary legal systems. I would like to suggest that it is incapable of doing so. The reason is simple. Wrongful losses result from the invasion of rights or a setback to legitimate interest produced by wrongful actions. Can there be a wrongful loss when a lawful but risky action, or if you like, a hazardous action, undermines the legitimate interest, not the rights of the victim? At glance, it seems that corrective justice precludes this possibility. But strict liability is not conceptually tied to invasions of rights, and that drives Coleman to interpret these cases as covered by the fault principle. According to Coleman, the key is to note that an agent can be at fault merely in virtue of engaging in an activity or for the manner in which she engages in it. Unusually dangerous activities are inherently faulty. This implies that someone is at fault by the mere fact of carrying out the activity, though no available precaution is sufficient to reduce risk involved to a diligent level. The problem with this reconstruction is that it turns all lawful but risky actions into inherently faulty ones. Contrary to what follows from Coleman's reconstruction, we can recognize that there are dangerous activities that should not be prohibited or discouraged. Research, development, and application of nuclear energy might be a case of this sort. The activity is lawful, not inherently faulty. These activities are in general permitted or sometimes even encouraged, and in no sense it is deemed that those who engage in them carry out an inherently faulty action. Also, the distinction between being at fault in virtue of engaging in an activity and being at fault in virtue of the way one engages in it should be called into question. I think the argument is flawed, because it assumes that there can be such things as natural descriptions of actions. In order to hold the distinction between fault in engaging in the activity and fault in the way in which one engages the activity, the description of the conduct must never include the way in which the action is performed as a defining feature. Suppose a person drives in the downtown area at 100 miles per hour after drinking 2 glasses of wine. Probably, when describing his action, that is, when defining what she is doing, we will include the way in which she drives as an essential element of this conduct. We will say that the person is driving negligently in the downtown area. Driving in the downtown area is permitted. Driving negligently in the downtown area is obviously prohibited. The second action, the one that is legally relevant to impose sanctions on to the engine, is not faulty in virtue of the way it is performed. In any case, it is as faulty as transporting explosive. In both cases, the agent is at fault in virtue of engaging the activity. There's no lawful way of driving at 100 miles per hour in the downtown area, provided there is a rule that forbids going at that speed. My point is that there are no actions on one side and ways of performing actions on the other. Even if it were possible to draw, this distinction would be irrelevant. Only descriptions that turn out to be appropriate in certain normative contexts and that allow us to characterize actions as lawful or wrongful are relevant. For a conduct to be faulty per se, it is necessary that the conduct is prohibited or that it can be subsumed in some general rule that defines negligence. In sum, if my argument is sound, Coleman cannot turn all cases of strict liability based on risk creation into cases of full liability. This strategy would not account for the distinction between strict and full liability in the sense that strict liability regulates lawful activities mainly, and full liability is always imposed for wrongful actions. This explains why, in general, public authorities take action against those who perform negligent conduct to prevent their deeds, but this is not the case with those who perform the action complying with all the relevant standards of care, even if their activity increases the probability of harm to others. On the other hand, if he intends to preserve the distinction, his conception of wrongful losses prevents him from explaining cases of strict liability based on risk creation in which the victim suffers a setback to his legitimate interest and not an invasion of their rights. My third criticism is regarding how he conceives primary and secondary rights and duties in tort law. Theories of corrective justice have been accused of misrepresenting the purpose of tort law, since they focus exclusively in its remedial aspect. Corrective justice the criticism recalled, just enters into the picture when primary rights and duties of the parties are violated. Only when the victim suffers a wrongful loss, corrective justice demands rectification. But the intervention of corrective justice in tort law shows that the aspirations of the practice have not been fulfilled. The normatively ideal world, from the point of view of tort law, is the one in which no person is wrongfully harmed. The most important aspect of the practice is preventive, not remedial. In particular, tort law establishes a set of primary rights and duties associated with harm prevention that, for conceptual reasons, cannot derive from the principle of corrective justice. If this is so, theories of corrective justice do not merely offer an incomplete explanation of the phenomenon, but a deeply mistaken one. The most fundamental point of the practice is not to compensate victims for the loss they suffer, it is instead to regulate harm prevention. As I see it, this line of criticism against corrective justice theories is not entirely convincing. It is true that in general corrective justice theories have neglected the place of primary rights and duties, focusing instead in the remedial aspect of tort law. But this does not mean that they have misrepresented the practice. Certainly, the regulation of risk we can reasonably impose on others with our conduct is not a distinctive feature of tort law. Criminal law, administrative law, and even public policy regulations also set up standards that define the boundaries of reasonable conduct and protect the interests of persons against the interferences of others. The distinctive aspect of tort law, arguably, is reparation of losses, not prevention. A different question is whether the reparation of a loss has the same moral value that is prevention, or whether the world in which the loss is repaired is normatively equivalent to that in which the loss never occurs. Of course, anyone would agree that a world free of harm is morally better than a world in which damages are paid, but this is hardly illuminating. In spite of all, this criticism invites reflection on the role of primary rights and duties in the practice of tort law. Grasping their importance in the practice might contribute a great deal in understanding it. Like Coleman, I think it's not possible to provide the general theory of the content and or the substance of primary rights and duties involved in tort law. I agree that in many cases the content of these rights and duties is determined by informal practices, but in many others, certainly, they are determined by formal practices such as legislative action or judicial decisions. In any case, the content of these rights and duties depend on social facts. Thus, nothing can be claimed of their substance a priori. Of course, this does not imply that it's impossible to offer an analysis of the kind of rights and duties that our conventions create. My thesis is that part of these primary rights and duties can be conceived as pertaining to the sphere of distributive justice rather than to corrective justice. As it will be clear soon, noting the extent to which tort law is also a matter of distributive justice will allow us to solve the problems I pointed out in the mixed conception. The rest of my presentation is devoted to this task. Conventions and individual rights and duties. What goes on in our formal and informal conventions? That's the thing. What kind of primary rights and duties are established by them? Let's begin with a hypothetical situation. Suppose Xenophon and Achilles are neighbors and their activities are partially incomplete. Xenophon breeds chickens and Achilles has ferocious guard dogs watching his property. From time to time, it happens that Achilles' dogs kill some of Xenophon's chickens. In every occasion, Xenophon presents a claim against Achilles. Achilles sometimes accepts the claim, but other times he rejects it. Their disagreements are mainly related to the fact that it is not clear at all whether, in the circumstances, Achilles had the duty to tie his dogs or Xenophon should have kept his chickens locked in the henhouse. After some time and a lot of debate, a convention arises between the neighbors. The convention they reach specifies a standard of reasonable care, the violation of which justifies a duty of repair, or the duty to bear the loss. It is important to stress that before this rule is created, we cannot answer the question regarding what demands corrective justice in a particular case. This means that the rights and duty defined by the convention cannot be evaluated by corrective justice itself. But what about distributive justice? In a world of strict liability, Xenophon is better off than in a world of full liability, and the latter is much better for him than a world with no liability. The opposite is true of Achilles. Regardless of which rule is fair in this case, I'm interested in pointing out the conceptual feature of the practice. Liability rules distribute resources among the members of the community. Of course, the distributive aspect of tort law was not completely neglected in the literature. Notwithstanding, it is not entirely clear what exactly is distributed by tort law. Among others, Sahi has a long book on the distributive aspect of tort law, and Peter Kane pointed out this same thing I'm mentioning here. My idea, although we all disagree about the nature of the rights and duties, my idea is that tort law distributes what I shall call indemnity rights and duties. These are rights not to be harmed in certain ways and correlative duties not to harm in those ways. Thus, under the full liability rule, Xenophon has a right not to be harmed by Achilles' negligent, reckless, or malicious actions, and Achilles has a duty not to harm Xenophon in any of those ways. A strict liability rule increases the protection received by Xenophon, since it grants him a right not to be harmed also by Achilles' risky activities and imposes on Achilles a correlative duty not to harm in that way. Indemnity rights, as I understand them, are part of what general roles called primary goods, goods that normally have a use whatever the person's rational plan of life. This includes rights in general, liberties and opportunities, and income and wealth. Obviously, whatever might be our individual project, we will need certain protection against the interference of others. A liberal state must secure a reasonable or fair share of primary goods, including indemnity rights. After that, the responsibility of the community ends and the individual responsibility for the chosen plan of life begins. That is so in virtue of the principle of division of responsibility. Many circumstances can weaken our responsibility for how our life results. Bad luck is an important factor. The state, of course, can make a political judgment regarding the extent to which the effects of bad luck in a person's life is to be neutralized. And it can decide not to neutralize bad luck at all, but it cannot fail to regulate the effects of wrongful interactions. A political community could hardly be built without regulating which harms we have to tolerate from others and which not. If the members of a society are to interact, relate to each other and cooperate, it is essential for the state to establish the boundaries of individual freedom in order to achieve a good balance with personal safety. At this point, the theory of indemnity rights might face a problem. If the purpose of indemnity rights is to secure some kind of autonomy space for individuals, what reasons do we have for doing it through tort law? Why could the state not protect the indemnity of persons through sanctions for injuries? So we have two questions here. One, do indemnity rights include a right to recover? If so, two, why should compensation be implemented through tort law and not, for example, through a system of social insurance? Regarding the first question, indemnity rights, like any right, are a set of valid claims. What claims define the content of each right depends on the normative theory. The content of indemnity rights could be given, among many others, by any of these alternatives. A. Any person who harms another shall be liable to imprisonment. B. Victims have the power to demand an adequate compensation in case they are harmed. C. Victims may demand an injunction to protect themselves against the interference of others that produce a setback to the legitimate interest, and so on. However, if indemnity rights are primary goods, in Rawls terms, and thus they might be useful for individuals to pursue their personal plan of life, we should discard that sanctions to injurers exhaust their content. Criminal sanctions will reinforce the protection to person's resources, but could not constitute the only protection granted by the state. It seems that alternative B, in some cases backed by C, B was, let's get it right, the power to demand compensation and demand, in some cases, injunctions, is closer to what is required by a normative notion of indemnity. What I'm advancing here, in short, my thesis is that indemnity rights not to be harmed, given the normative theory that defines the nature, necessarily include a right to recover once the harm is suffered. Only compensation keeps the victim in a constant level of resources that allows her to continue with her plan of life as if the interaction had never happened, at least in the ideal case. As to the second question, it is true from the point of view of distributed justice there is no reason to secure indemnity rights through tort law. The state might fulfill its duty to secure a reasonable level of indemnity by implementing a social system of compensation for victims and criminal sanctions for injuries. But if the state did that, it will not recognize the binding force of justice between the parties and consequently will not honor the principle of division of responsibility. These principles require the implementation of institutional corrective justice. As I understand corrective justice, its purpose is to rectify unjust interactions. And unjust interactions are those in which the parties' indemnity rights and duties are violated. In ideal conditions, the principle of corrective justice would be accepted for free and equal persons to regulate their private interactions. How does corrective justice regulate private interactions? Regardless of the situation one enjoys in society and how well one's life results, individuals will recognize that they must reciprocally respect their rights. In the private interactions, individuals ought not to use someone else's resources without consent. For that reason, every interaction must respect indemnity rights. This scheme suggests that tort law is a very complex institution. First, it's secures certain levels of indemnity by means of compensation. And also the state certifies its duty of distributive, the state certifies its duty of distributive justice. Providing compensation certifies its duty of distributive justice. Second, it allows the realization of justice between the parties, and in that way it certifies corrective justice. Finally, it honors the principle of division of responsibility, given that the state stays aside of individuals' private transactions and only offers its assistance to enforce the fair terms that regulate interactions between particular persons. Regarding the connection between distributive and corrective justice, I will say that the explanation I have offered is grounded on the idea that the practice of tort law admits two readings, one distributive and the other rectificatory. In holding this institution, the state secures indemnity rights of the parties. Liability rules in each community determine the content of indemnity rights and duties. Thus, every adjudicated process in which the victim seeks compensation for the loss she suffered contributes to the preservation of a system that fulfills an important distributive function. That is, make corrective justice a part of distributive justice? Certainly not. When someone suffers a loss from a wrongful interaction in violation of her indemnity rights, there are reasons of distributive justice for the victim to receive compensation. There is not a specific reason for the injurer to make good on the victim's loss, but imposing on him the obligation to repair satisfies at the same time corrective justice demands. Tort law is one of many examples of institutional economy. The state avails itself of the effects of corrective justice to fulfill its duty of distributive justice. My account could also be suspected of incurring in the vice of circularity. According to what I said, indemnity rights and duties are a matter of distributive justice. Therefore, the definition of what counts as a wrongful interaction belongs to the world of distribution. Only once this is defined, corrective justice can be applied. But at the same time, the practice of securing indemnity rights and duties is carried out mainly by tort law, by individual adjudicative processes, which are supposedly a matter of corrective justice. This would imply that corrective justice contributes to the definition of the fair terms of interaction that then will fix the basis of rectification. How can corrective justice rectify the same that contributes to define? Imagine a case like the one of Xenophon and Achilles with the dogs and the chickens. If there was no regulation for it and the case was presented to a judge, he will have to specify under which conditions compensation is required. He will have to define whether Achilles is liable is free from liability, or on the contrary, whether he is responsible and in what way. If he is strictly liable, or by fault. These decisions are based on purely distributive judgments, because they define the terms of interaction between them and secure the different degree of indemnity of each party. Suppose that after these rules are defined, Telemachus and Persephone have a similar problem, and they also end up in front of a judge. For the judge, this is a much easier case than the first one, for he will simply apply the already established liability rule according to which Persephone has to pay damages to Telemachus, for example. The second judge has not created a new distribution. He has simply rectified the wrongful interaction in light of the set of rules endorsed by the state. Compensation moves resources from one to another, but it does not alter the distribution of indemnity rights and duties at all. It does not modify the underlying distribution of rights, therefore it is purely corrective. Although this is an autonomous principle, the state can choose to use it to enforce or failing to enforce such by enforcing or failing to enforce such principle to maintain or change the current distribution of rights. It is, if the state stops implementing corrective justice in certain cases, then the indemnity rights of the parties will be reduced. I will read this last part. Regarding the objections are raised against the mixed conception, how my theory accommodates them. The theory of indemnity rights and duties explains tort law by showing the way in which a practice like the one described by the mixed conception can be understood in more fundamental moral terms. It shows the connection between an institution that imposes the duty to compensate certain losses on those who cause them and the state's concern in securing a reasonable scheme of personal safety and liberty of action on the one hand, and implementing the demands of private justice on the other. Establishing a scheme of indemnity rights and duties is a matter of distributive justice. The The particular normative link between the victim and the injurer in tort law adjudication is a matter of corrective justice. At the same time, this theory shows how both principles expressed in tort law integrate a broader conception of liberal justice. In this sense, it is informative. Furthermore, for liberalism, it might even be a plausible justification of the practice. Regarding primary rights and duties, the theory understands that tort law distributes rights not to be harmed in certain ways and duties not to harm in those own ways. In this aspect, my theory differs from others that locate the concept of right and liberty at the core of tort law. Tort law is not a remedy for invasion of rights in general, but for the invasions of indemnity rights and duties. Indemnity rights and duties are correlative. Whenever Xenophon suffers a violation of his indemnity right, Achilles violates his indemnity duties, and when this happens, all the requirements for recovery are met. A. Xenophon suffers a loss. B. The loss is caused by Achilles, and C. Achilles' actions pertain to the class of actions subject to liability by the law of torts, depending on the indemnity right affected. Yes. Also, indemnity rights and duties. Indemnity rights and duties theory explains secondary or compensatory rights and duties. Indemnity rights include, for informative reasons, a secondary right to recover. For normative reasons, a secondary right to recover. As I said before, a right not to be harmed that did not include a right to recover would not keep its holder resources in a constant level to pursue a reasonable plan of life. This indemnity right, as a matter of distributive justice, has no specific correlative duty. It just implies that someone has the duty to compensate the harm suffered. When the state decides to correlate indemnity rights with obligations of the injurer, it satisfies its duty of distributive justice. Secondary compensatory duties, in turn, can only be explained as a matter of corrective justice. In ideal conditions, individuals would accept the principle of corrective justice to regulate their private interactions. Finally, for a reason that should be obvious at this point, the theory can explain full liability and strict liability cases, and the distinction between those forms of responsibility. Full liability and strict liability are two ways of defining, following some criteria of justice, the parties' indemnity rights and duties. I'm not going to read the last part, but the idea of the last part is that, of course, indemnity rights and duty can account for both intuitions Jules Coleman trying to preserve, because as to well-being, giving indemnity rights to people protects their well-being. It keeps them in domain of their resources to pursue wherever the plan of life they want to pursue. And on the other hand, by implementing corrective justice, tort law secures individual responsibility, makes us responsible for the consequences of our actions. So that obviously there is a lot of Jules' influence in all these ideas, also some various influences, but the thing was trying to show that his basic intuitions are not supported by the mixed conception, but there are other alternatives that could support it. Okay.
Thank you very much, Diego. Now it's time for your 15 minutes reply. I remember yesterday you said you would start easygoing, but that would gradually change, so Diego might get serious punishment.
No, it would not be punishment. It would be correction. That's how we started, right? Well, that was excellent. I admire any effort to create an original view, and so I really appreciate the effort. Now, I guess I'd only like to focus on three. First is the mixed conception and whether it lacks a foundation. And the second is how we should understand what it is for there to be a right that we call an indemnity right. What that is. And the third would be why you think indemnity rights are matters of distributive justice. I mean, that something gets distributed doesn't mean that that it's a matter of distributive justice. That's just it. All right. So let's start with the mixed conception. Certainly, I want to just groping for that it only imperfectly realized. Because I don't want to be wedded to the risk and wrongs, it clearly is the mixed conception, but I don't want to be wedded to that because I'd rather be wedded to the idea. It's more helpful if we think that the mixed conception is an imperfect way of trying to articulate something that I can articulate better now, but still may be imperfect, you know. So it's certainly true that in the mixed conception, wrong and responsibility were central. Wrong was central, and wrongful was central to help distinguish the category of losses, those which called for repair as a matter of justice, and those which did not. So wrongfulness was, that was the role it played. And responsibility played a relational role. It explained why these losses, which were wrongful, were yours, someone in particular, to deal with. Because that person was responsible for them. So that's the way it played out there. And that's probably mistaken. Now, the view that I ultimately came to was that the wrongfulness, the duty part, was what explained both the wrongfulness of the loss and why this person had to pay for it. That is, that the responsibility part, they were not separate, right? And that the wrongfulness was because wrongfulness was a breach of a duty that was relational. And it was because the duty was relational that the person who breached the duty to another person in particular, and thereby incurred secondary duty to that person. It wasn't a taking back of a loss that is yours through the theory of responsibility. Rather, it was the aptness of, a particular set of normative relationships had been developed between the two of you. They had a primary and a secondary character. The primary character was to take the other person's interests into account in an appropriate way. The failure to do that when it had certain adverse consequences gave rise to another sort of duty, which was to be explained in terms of the primary normative relationship. And the content of the duty that you have to another person includes an element of responsibility, which I can put in as follows. Namely, the primary duty is the duty not to cause harm to another person through a failure adequately to take appropriately into account the interests of the other person and their security. And that includes the responsibility element as well as which interests you're responsible for and so on and so forth. So the mixed conception separated those two. The more sophisticated version did not. Okay? Either case, your view would be that it lacks a deeper foundation, saying that corrective justice only applies to one aspect of that, namely the fact that there is this duty of repair that's grounded on this primary relationship, and since you can get repair in one way, and you can get responsibility, appropriate response to responsibility in some other way, what's missing is an argument for doing it this way. Right? So, it's no answer you might say to that to say, well, this is what corrective justice requires. Because then the question just is, well, what are the values associated with corrective justice? Okay, now, there are probably a lot of things I have to say about that. So I want to resist the idea that there's no foundation for that. Right? There are no values for that. I mean, that seems to me to be odd. But let's just focus on one because it would be a of my discussion afterwards, and that will be accountability. That is, what corrective justice, the value that's associated with this particular practice of corrective justice, namely enforcing these primary rights, relational rights and duties, is that it makes individuals accountable to particular persons, and that would not be achieved by these alternative systems. These alternative systems would make me accountable for, namely the loss, or they would make someone else accountable for the loss, and I would be left to answer for my conduct, but I would not be accountable to this particular person. And the whole idea, I think, that underlied the so-called bilateral critique was not just the relational idea, but the accountability idea. That is, you have rights. It's appropriate for you ex ante to demand of me certain sorts of conduct, and you're right to do so. When you have the right to demand of me ex ante is that I take your interests adequately into account when I undertake various undertakings. That is, when I engage in certain risky activities, you have a right to demand of me that I not do this without regard to what the impact of my activities might be on your legitimate interests. And that under certain sets of conditions, you might say that I'm obligated so to do that. Right? Now, when I fail to do that, and in my failing to do that, I harm you in a way that falls within the scope of those interests, it's appropriate that you now have demands against me in the same way, to use the John Gardner example, about the continuity of reasons, the thought that you have the demand that I do what I promised and I fail to do what I promised. It's not like you run out of demands. That there are other things that you can now ask of me normatively. What you can ask of me is that I do something, to use the Gardner phrase, to mop up my mess. It's not just that anybody can do that, it's that you can do that. Anybody else can be disappointed in me if I fail to do it, but you stand in a special kind of relationship to my doing it. You have certain claims against me that other people don't have. And that this relationship of accountability and whatever value we associate with it is the feature of tort law that is embodied, not as well by the mixed conception as by its replacement, but is sought after by both. Okay? And so you have to think that there's something to be said for systems of private accountability, to think that there's something special about corrective justice. This is clearly not true about the annulment thesis, right? Because in the annulment thesis, it's the getting rid of the wrongful gains and the wrongful losses, and that whatever the value is, it's the value of undoing certain kinds of things. And even in the John view about the transactional, there is, what you're looking at is undoing the transaction. You're not really focusing on the specific normative status of being accountable to. Right? It's the fact of undoing, not the fact of having to answer to. All right? So those would be different views. So if you think there's something special or important that is captured in this area of the law by the notion of being accountable to, which as opposed to just being accountable for, then that is something you would think is valuable about this practice and institution. Quite apart from whether it sustains an institution of distributive justice or anything like that. And this would be an explanation of why you might want to have such practices, even if the net effect was to put people back in situations that were distributively unjust, thinking that, that's the sort of thing we should deal with, but not here. And if we deal with it, we should deal with it a little bit here, but not fundamentally here. Here, we're concerned about a certain kind of distinctive normative relationship that creates certain kinds of standing relationships with one to another. So that would be the answer I would give to the thought that it lacks a foundation Yeah, but I think right, it's not in the mixed conception, but that the mixed conception was groping for the relational idea, and I was trying to explain what the value is of the relational idea, um, which would make it independent of distributive justice. So I don't think we have to hook it to the idea of distributive justice in order to understand what its value might be. In fact, disconnecting it from distributive justice does a better job of explaining what its value may be and why we're less inclined to think that the distributive justice features really are prominent in the law of torts. Not that they don't show up, because the law is the law. And that'll be part of my last lecture is the law is a messy mess. And, you know, the thought that there isn't going to be a little of this and a little of that, that's crazy. And then a little of this that makes sense. You know, you might say, gee, it would be better if it was pure and it didn't do this and it did this somewhere else, you know. But it never works that way, okay? And expecting it to work that way would be, you know, I'm not sure how helpful it would be. So, now turning to your views, now that I have tried to say something about my views. So now turning to your views, I am puzzled that I think it's just, I hope what you need to do is to help me understand why the notion of an indemnity right is not just a semantic move as opposed to being a substantive move. Because there is the idea that, of course, what we're trying to do is provide for this an appropriate mix, a defensible mix of security and liberty, you know, kinds of freedoms to act in accordance with certain norms that also reflect treating other people as points of view, as constraints on what is legitimate for us to do, and so on. And that with some vision in mind about what the value of that form of liberty is and the value of the kind of security that would be obtained when individuals did act in the way of regarding other people as constraints on what is permissible for them to do. All right? And that, to a certain extent, that we could say that whatever we came out with, we could say those constituted a distribution of risk. We could say that it constituted a distribution of insurance. We could say that for certain activities we have to act as our victims' insurers. Right, there are lots of ways of expressing this. We could say that we have to indemnify those we put at risk sometimes. We could say all of those things. But the idea is the same, it seems to me. And the idea is, I'm not sure what's gained by thinking of it in terms of primary rights. I think they are. I'm not sure they're even primary goods in the Rawlsian sense. That is, there are things which are primary goods in the Rawlsian sense that the reason they matter to us, no matter what our ends are, just is that if we have norms that regulate our affairs in certain ways, such that we can pursue our projects, plans, and goals within the constraints of treating others as constraints on what we're free to do, then those things are primary goods because they'll be valuable to us no matter what our projects, plans, and goals are. And the norms that constrain us may be primary goods as well. But the rights, we don't need the notion of rights, I don't think, in order to capture that idea. We need the notion of rights sort of one could use the notion of rights as a philosophical tool to help to understand, precisely the relationship between the compensation and the underlying grounds for it, namely that it's all about rights, it's all about duties. But we don't need the notion of rights and duties to do that. We can have the notion of we're just, when we engage in various activities, we have to, part of what it means to treat other people as ends in themselves or as constraints on what we do is that we have to act as their insurers sometimes, or the distribution of risk has to reflect that way of taking, according to norms that all of us could reasonably accept, or something along those lines. So I'm not absolutely sure what is added by the idea of indemnity rights that isn't capturable in some other way. And I'm just might have been missing something. I just don't know what it is. And the last point is kind of a derivative point from that, which is to be sure what those things are allocated ultimately. That is, they're things all of us have as against others, and which are triggered under some set of conditions and not others. But I'm not sure that that fact alone makes them matters of distributive justice, because what would have to make them matters of justice, that is, everything gets allocated, our wealth, our money, our compensations, our whatever, but that isn't what makes them matters of distributive justice. What makes them matters of distributive justice has to be something else. And so I wasn't sure, I heard the argument that they were part of the primary goods, and that's what made them matters of distributive justice. But, and maybe that's all you wanted to say. I don't know that that's a persuasive argument to me, because I'm not sure why they're primary goods, and so on. They're important, valuable. Maybe they contribute to our self-respect and dignity and our capacity to pursue our projects, plans, and goals, and that makes them extremely important. Not sure why that would make them matters of distributive justice. I'm not sure it matters whether they're matters of distributive justice. They're rights that are important for us to have because they contribute to our well-being and welfare, and that it would be a less desirable world in which we had those sorts of protections, and so on. But so that's just basically the set of thoughts I had.
Thank you very much, Professor Coleman. Now it's time for questions, please. Of course, you have priority.
No, just a few comments before the discussion.
You realize you're the only person who's chosen.
Yeah. The idea was that what I call indemnity rights fit the description of primary goods. And the whole Rawlsian discourse is a liberal discourse, it's understandable. The morality of it is quite obvious. You can agree or disagree in the how you call it, not assisted.
Domain,
domain, how big should it be or not, but you understand what this is about. It's about global liberal justice. And I think that what solves is that it allows us to understand certain discourse, the legal discourse, in terms of another discourse that is more familiar, more fundamental, that is the moral discourse. And this is true whether you agree, even if you are skeptical, you can say, look, this discourse fits into this other one. So even if you are more skeptical, you can say that this is a good conceptual analysis. And the main problems that it solves is that given that this is a normative account based on Rawlsian theory, you can derive secondary rights from primary rights with no problem whatsoever. If it is true that it's a primary good, and primary goods are supposed to allow you to pursue your plan of life, then no other remedy, like prison to the injured, will allow you to pursue your plan of life. You need compensation as a conceptual matter, but for normative reasons.
But you might, but then you might say that what's required is the right to compensation, not the primary right on which the right to compensation.
Yes, I thought about that, and I think it was insatisfactory, because then autonomy and my plan of life wouldn't be protected, because I would be subject to all the takings they want to do, provided they're willing to pay the price.
But it's a primary right of indemnification. I understand a primary right of being indemnified, not being a right to do as you see fit, but to have certain consequences of of others' actions
Yeah,
nullified. So
yes.
so that
No, in a way, we don't have, not all indemnity rights are equal. We have more broader, more stronger, or some indemnity rights are very thin. For example, when we are against justified conduct of the injured, my indemnity right is really, really thin because I only can get ex post compensation in that case. So my indemnity is protected in a very weak way. They are even weaker way. For example, I can try to prevent him to talk, but if I cannot do it, I cannot ask for compensation. That would be a indemnity right, very, very thin, very weak. So I think
what is the content of indemnity there?
Very weak one.
But what is
Almost none, and that's a political decision. We have to, maybe indemnity rights must not be justified necessarily, but maybe there are indemnity rights as a conceptual matter that are unjust rights. We should have in certain contexts stronger indemnity rights. But the thing is that it's conceptual, and what the work that does is conceptual. It allows you to translate one discourse into another one, and frees you of all the problems of having secondary duties and rights from primary rights and duties.
Well, I would say, just if you don't mind me saying so, that that might be true if I thought that the notion of indemnify, as you use it, was clearer than the notions which are used in the law of torts. But I think it's unclear that they're clearer at this point. That is, I understand the idea that take a phenomena like intention. I finally bring up Davidson and analyze it in terms of beliefs and desires. Well, that's a step forward, but the extent to which it's a step forward depends on how clear we're understood about the notion of what belief is, what desire is, and the way that's supposed to come together for intentions. So that the idea of tort liability and duties of repair and all the concepts that we use in proximate cause, all the ones that are in law, are replaced by these.
Right.
Yeah. Well, the question
They're
is.
not replaced.
Well, they're semantically replaced. They're not metaphysically replaced. Not reduced.
I would say that indemnity rights depend. The extent of indemnity rights depend on how these rules are regarding proximate causation,
Right.
regarding which losses are repairable, which
Okay.
not, which the liability.
Maybe I'm the only person here who's never heard the expression an indemnity right before. I've heard the expression of being indemnified, and it usually goes in the other direction. It goes in the direction of a person who's engaging in activity being indemnified for the risk that they undertake. Right? So when I think of being indemnified, I think of it as protecting the person who's imposing risks on others, rather than.
It's different.
Yes.
More than
it has to be.
continental tradition. This might be a problem.
Okay, that's okay.
Someone warned me about
It
this.
would not be the first in my family.
No.
Please.
So, I'm not sure if I have correctly grasped which parts of your operation are necessary to engage with Jules and which parts are your own proprietary additions, which are make a positive case for something different. So this is where my line of questioning lies. So here's a picture that seems about right to me about the relationship between distributive and corrective justice in tort law. And one of the attractions of it is that it doesn't matter very much which conception of corrective justice we put into this space. This is just part of its appeal, so we don't have to fight about that in order to do it. So here's a story. People owe each other repair for the wrongness they commit, and that's in some version or other going to turn out to be corrective justice. Parts of the law are sometimes used to institutionalize this arrangement by not just recognizing that people have those duties, but by giving them powers to enforce them, to have them recognized, and then to obtain recompense by enforcement mechanisms at the end. So all of that is familiar from tort law, but it's also found in contract law and other parts of private law. soon as we do that institutionalization, we have to confront a distributive question. How are we going to distribute this wonderful thing that we've just come up with, which is the institutionalized protection of what we're calling corrective justice? And that's, on any view, a problem of distributive justice. That there are authorities, some of them are more organized than others, but they might be legislatures, executives, or judiciaries, and they have to confront every time the question, even when they are making small decisions, how are we going to distribute this wonderful thing that we've created, which is the institutionalization of corrective justice. And this seems to be a totally benign way in which corrective and distributive justice live together. Benign in the sense that corrective justice is the first step in the story, and it explains the structure of what goes on, and distributive justice is the second step, and it explains the process we go through to decide who's going to get it. Through the institutions, of course. Other people will get it outside the institutions, but through the institutions. And so I suppose my question is, how does that differ from the story you're telling? So you added lots of things. I know that. So you call them primary goods. I don't so much care what's a primary good because I don't have much time for roles. But you added that. So I knew that was an addition. And I thought lots of other things might be like that. They might be things that we could take them or leave them and still keep the basic picture intact. So the question is, was that the basic picture, or have I completely misunderstood what the relationship is supposed to be between the distributive and corrective?
Yeah, well, I wouldn't say that what you distribute is corrective justice. I wouldn't put in those terms. I would say that what you distribute is some right to be safe of interferences of others.
Yes, but that is done by other ways than by tort law.
Yes,
so criminal law does that too. Right? We distribute.
Of course.
Yeah,
I'm seeing
tort
law as a part of many institutions.
Okay, no, that's good. But so if I were speaking for Coleman, I would say, okay, that's great, but what's distinctive about the private law way of doing it? Well, here's one thing that's distinctive about
compensation.
The mechanisms that we distribute include the reparative feature that I mentioned, and the power of invoking the institution that I mentioned, and a few other things as well. I don't care very much like you whether we call that corrective justice, but that's more specialized. You don't find that in criminal law. You don't find it in every other branch of the law either. Administrative law imposes filters, leave to take action, and so on. All of those things are distinct, even though your story doesn't make them distinct.
No. Yes.
And you might say, well, great. So
compensation
you tell a story that we can all agree with, and Coleman adds something. Namely, in tort law, it's corrective justice. The bits I mentioned. Again, the labelling is not important, but the bits that I mentioned, the reparative feature and therefore the relational feature, and therefore, or maybe not therefore, additionally, the power to invoke the institutional directness of the court.
I think that those are all features you have to explain. You have to account for them. They're truisms, in a sense. Those relationships.
Agreed. I thought he thought that too.
Yes, I do. And I think those are the features that are distinctive of corrective justice.
Yeah. Well, in one version or another, so the nice thing about putting it this way is I sort of escaped from the mixed conception and all these things.
They're not the features of
corrective
justice, I think. They're features of tort law. And corrective
that
justice
doesn't
is half
matter.
of tort law.
We're all agreed that doesn't matter.
No, but corrective justice is a half of tort law. Just
No.
half of it.
There's a reason to call it corrective justice in the story I told you, which is that you need to have some kind of justice that's not distributive justice that's being distributed. Right? So I told a story in which we needed the contrast because there's a new subject matter of distribution that's been created by tort law, and it is itself a kind of justice. It may not really be being created, it may be being recognized, but one way or the other, it's not. It's a thing to be distributed rather than a distribution.
No, I would say that tort law creates a particular way of addressing the problem of indemnity rights. A particular way, which uses the effects of another principle of justice, private justice, corrective justice, in order to fulfill its obligations of distributive justice. The state has these complex institutions and principles at the same time, because...
But that sounds different. That sounds like corrective justice is part of distributive justice rather than something to be distributed.
It's not part. There is a relationship, of course, because if you never recognize demands of corrective justice and you don't implement another institution like insurance, social insurance, you wouldn't have distributive
by creating institutions of corrective justice that you create something to be distributed, and now you're going to distribute them. But if you didn't create them, you didn't create anything to be distributed, so distributive justice be damned. It doesn't matter here.
No.
Yeah, that's different from what you said.
No, we will implement other institutions. Without implementing corrective justice, you could distribute anyway.
He has something else that the institutions are supposed to distribute.
Which is?
The indemnity rights.
Indemnity.
Now I don't understand what they are. They just sound like
Right.
rights. So now I don't understand what they are that makes them distinct from other rights. Because they
No, it wouldn't, but that's not Tort Law. Tort Law has the solution that it's mixed.
No. Now you're trying to get it both ways. Because you said there are other institutions that deal with these indemnity rights. So you can now say, but that's not Tort Law, because you're saying the thing that gets distributed are indemnity rights, and they can be distributed. So here's, John thinks that the thing that needs to be, here you're actually both fundamentally disagreeing about what the primary object of distribution is. So this is my great role in life. Explaining what everybody else thinks. Right, okay. And so you both think that there has to be something distributed, but you have different views about what. So you think that the thing has to be distributed is indemnity rights to persons, and then they have to be. Once they're distributed to individuals, they have to be protected and enforced in a variety of different kinds of ways. And tort law will enforce them in some ways, and criminal law enforce them in other ways, and pricing mechanisms in some other ways, but they can all be enforced. But the primary thing that gets distributed, not the only thing, are indemnity rights. John thinks, in order to explain tort law, I don't have to introduce the idea of indemnity rights at all. I just have to introduce this idea that there are private wrongs, ways we harm one another, and there's something good, valuable about securing repair for those losses that we suffer, that we could explain in a variety of different kinds of ways. We could say what's valuable about it is the accountability story I gave, or we could say what's valuable about it is that it protects, makes people more secure in their holdings. We could say a lot of things about it. And now the question is, so we want to make sure that happens. And now we have a question, how should we make sure it happens? Will we give access to this? We can make sure it happens. We could think it's a valuable thing, but we don't want to do it institutionally at all, in which case no question about its distribution comes up. We may just think and leave it to people to do it privately as they see fit. But we might think that that's a bad idea, or it would incomplete, and it would have all sorts of distortions. So we want to create institutions that do this. Then we ask the question about who will this be distributed to, and on the basis of what conditions will they be able to trigger it? And we ask ourselves those questions. And we don't introduce the idea of an indemnity right that gets distributed. We just introduce the idea of access to this kind of form of protection of your interests. And then, of course, in that institution, we'll have to figure out which interests get protected, when you can make these claims, and that'll be all those things. That's what the institution does. That's certainly my view, right? That the institution does this. We don't have that a priori. Yeah.
I wonder, John, about your story, whether you are missing a layer, and then perhaps we reconcile and all this, Diego's view. The way I think of it, and I think that Diego thinks of it, and we could borrow, for example, the Calabrese and Lame distinction. First, we need to decide who has which entitlements, which is a distributive question. This is the first layer. Then we also have the question, how do we protect that? And then here gets we create a institutionalized corrective justice, which is the second layer. And then I think what we're interested or want to argue is that we have a third stage, how we distribute the corrective justice. But for me, it raises the question, what's the difference between the third stage and the first?
Okay. So I deny that the first stage is a proper stage.
Why?
Right? Because entitlements aren't yet institutionally arranged, and there's nothing to be distributed. We have entitlements because we're human, institutionalization is before distribution, not after. Entitlements, they distribute themselves. I have rights, I have them for good reasons. And somebody is going to come along and organize them into legal systems and other
Or not.
sorts of, or not, yeah? And it's when they start to do that that the distributive justice questions arise.
Though some rights will arise as creations of these institutions.
Yeah.
But that there is no general political philosophy question. I guess I'm with John about this, and you guys are on the opposite side. There is no question in political philosophy as to what are the basic entitlements and how should they be distributed. Right? There are entitlements like, it depends, I have certain rights as who I am. If we're organized as a political culture, then I have other kinds of rights in virtue of our being organized as a political culture. And how do I defend those rights that I have organized in political culture? Well, I offer a substantive theory about that. Have a political culture of a certain kind means that as participants with certain costs falling my way, I have to be able to participate in certain ways. It would be wrong to do that. Other people should not be allowed to prevent me. I offer those arguments. I don't offer an argument that says there's a state which has to do anything. Right? This is my reason for thinking there should be a state to do something. Right? That I've got these things.
I don't understand that claim.
So,
I find that it's a reason, because the only thing you could say is that that's the way we do it.
No, quite the contrary is what we should do.
so as Jules is presenting it now, it's boiling down to a deep contrast between moral realists and moral constructivists. He and I are moral realists. We think that actually there are moral reasons to do things, and the state is an apparatus for doing them. Whereas the counter argument, which is from the broadly Rawlsian and before that Kantian tradition, says no, even the original moral reasons have to be constructed out of something else, which moral realists simply deny. So that's where the battle lines are being drawn now. I didn't put it that way, but that was the way Jules was taking it.
But would you just say that we, in a way, we have rights because we can be harmed? Harm is first?
No, there are many.
Because I would say the opposite. You don't have any criteria to say that something is a harm unless you can define.
We are just doing moral
what is
philosophy,
your right.
so there are just lots and lots of reasons for doing things, and sometimes they have the requisite force that they become duties, and sometimes the fact that they become duties is based on the interests of a particular person, and then we call them rights, and then the question arises, what are we going to do about it? Are we going to protect them? Maybe, maybe not. Some rights we protect, some we don't. When we protect them, though, now we have a distributive question.
I don't think that there is such a thing as protection of rights. Rights are protections of
Okay.
something, some
Yeah,
interest.
So there you go. That's again, a
conceptual.
classic manifestation of the basic moral dispute.
Yeah.
Right? I think rights are just the grounds of duties, and I have a moral right that the people who promise me things keep their promises, which grounds duty on them to keep it. And that's just a way of saying that it's because of my interests that they have that duty.
But it's very obscure, this idea of right. What does it mean, a right? It's just not a set of protection, a set of valid claims.
No. That's a way of institutionalizing a right. Then you're talking about a legal right, a way that a right has been turned into an institutional operator that can trigger various sorts of maneuvers in a broadly procedural framework where somebody can go and say, it's mine, and other people say, yes, it's yours, and then they'll send the bailiffs for it. And I say, why bailiffs? We haven't got bailiffs yet. We're talking about your rights. Yeah? None of that stuff exists. It's an open question whether we're going to have it. Right? And once we've addressed that question, then distributive justice lives. Because now we want to know not just what rights we're going to institutionalize, but in the melee of conflict among the different rights we're going to institutionalize, how are we going to distribute the institutionalization?
But
People have gains
this
and losses.
disagreement is too fundamental, I think. So you cannot use this conception to attack my theory.
No.
My theory is consistent with my own conception.
No, that's right. All I'm saying is that your constructivism is wrong. That's why I said I was being very, very cautious.
Now we can
Anyway,
have
but
it
I said,
together.
I don't go with Rawls. I said,
Okay.
I don't hold with the Rawlsian, because Rawls is he's your master constructivist, and obviously his picture of how all this works doesn't fit with what Jules and I have been trying to say. I mean, Jules occasionally has his constructivist moments in his work as well, but
I think we would agree.
but he has more realist things than constructivist.
Maybe you change because you strongly embrace the Feinberg idea.
Well,